SJC-12325, James B. Nutter and Company and others, v. Estate of Barbara A. Murphy and others.
Thank you.
Mr. Bowles, good morning.
Good morning. May it please the court, my name is Daniel Balls. I represent Brett Jameson. There are three things to know about this case. Most importantly, the statutory power of sale is a power defined by statute, not a power granted by statute. Chapter 183, Section 21 defines a specific power of sale that may be incorporated into any mortgage by use of four words: statutory power of sale. The adjective statutory distinguishes it from some other power of a sale. By the plain terms of the statute, the statutorily defined power is an available remedy if and only if it is incorporated first into the mortgage by reference. Any power of sale in a mortgage, including the statutory power of sale, is a contractual power. It's a power of attorney, or at least a subspecies of power of attorney. As a matter of mortgage law and as a matter of contract law, the power is strictly limited to what is unambiguously granted.
So the provision we're dealing with says lender may evoke the power of sale and any other remedies permitted by applicable law. At this sale, lender or another person may acquire property. That is known as a foreclosure sale. So that absence of that word statutory before power of sale kills them. Is that your view?
That is one part of it. So the remedy that says this is known as foreclosure and sale then continues to say in any lawsuit for foreclosure and sale. So traditionally, the statutory power of sale is a non-judicial process, which is the second piece of this case.
But isn't that second sentence giving the lender extra powers? In any lawsuit for foreclosure and sale, lender will have the right to collect all costs allowed by law. Lender may require immediate payment in full under this paragraph, right? So it's not an extra power, but it's a limitation on the power?
I read it as a limitation on the power because further down in the paragraph, there's a notice that must be sent to the borrower that says that there will be a right to assert defenses in a lawsuit for foreclosure and sale. This is a notice very similar to that in the Pinty case. In the Pinty case, the court emphasized that sending a letter that promised that there would be a right to assert defenses in a judicial foreclosure case risked disastrous consequences if the lender then proceeded to foreclose non-judicially. So this mortgage either is a mortgage that contemplates a judicial foreclosure and must be foreclosed as such, or this is a notice that requires borrowers to be sent a misleading and deceptive letter. The absence of the word statutory, I think, alone is sufficient in this case. But to the extent that there's any ambiguity, the inclusion of the language about a judicial remedy indicates that that is the reasonably deduced intention of the parties from the mortgage.
Now, what does Fannie Mae language say?
Fannie Mae's standard language, which says may invoke the statutory power of sale or any other remedy permitted by applicable law. So it has the addition of the word statutory. The model form states that it is a mortgage granted with power of sale in the very beginning of the mortgage, and the language about the letter says the lender, must send a notice to the borrower informing the borrower of the right to bring a lawsuit to assert any defenses that the borrower may have to foreclosure.
So this is a variation on the theme of the Fannie Mae language, it sounds like.
This is a variation on the theme of the Fannie Mae language, but not from Massachusetts. So it's language imported from another state, presumably a judicial foreclosure state, because there is a clear reference to that process.
And that's comparable to another case we had where they were using language that was generic and was not applied to Massachusetts. I forget the name of that case, but Justice Botsford would remember, but she's not here.
I believe that was Emigrant Mortgage versus Pinty, in which the court found that strict compliance with that notice requirement was, any sale that did not happen strictly in compliance with the terms of the mortgage, including that notice requirement, was a void sale. So in this mortgage, a sale would be void unless it informed the borrower that there would be a right to assert defenses in a judicial proceeding. I should emphasize that it's a notice provision of the mortgage, so this is a consumer protection piece of language. The notice provision doesn't create any additional rights that the borrower didn't already have, so its only purpose is to provide accurate information to a borrower who might not otherwise know it.
So if you are right, what is their remedy upon a default?
Massachusetts permits 3 ways to foreclose. One is language that includes a power of sale may foreclose in accordance with that power. My position is that is not an available remedy. The other 2 are governed by statute, General Laws, Chapter 244, Section 1, which permits foreclosure by action or foreclosure by entry. The most likely and quickest remedy would be foreclosure by action in this case, which would include 1 lawsuit in which the borrower would be permitted to assert any defenses as necessary. Chapter 244, Section 11 does permit a power of sale to be foreclosed following a power of sale foreclosure following a judicial action. So there is a provision in Massachusetts law that permits a judicial action for foreclosure followed by a conditional judgment. You owe this much money by this date. If you do not tender the money, sale will be ordered in accordance with terms set by the court.
We talk about what the land court's been doing for a number of years, maybe at least since 1995. Are they saying if you have that language, any other remedies permitted by applicable law somewhere in the mortgage, as it was here in paragraph 20, that's enough for a statutory foreclosure?
There were a number of cases from the land court that found that this was enough. All of the cases prior to this were not contested cases. So either there was a default judgment or there was an assent by the other side. I think the land court made an error of law in that. I think the language, any other remedy permitted by applicable law, is properly read as a reservation of right, saying, so there was a reference to this power of sale, or a reference to, in this mortgage, the remedy it defines as foreclosure and sale, which, so I think that's language that's saying, this isn't the only remedy that they may use. They may still bring an action on the note. They may still foreclose through entry. They may still foreclose through action, so long as it's something that they already have the power, but that this is not a power permitted by applicable law unless it's first incorporated. So to say that it is incorporated because it's permitted is circular. One of the cases the land court cited said the lender may may invoke the power of sale ... permitted by applicable law. I think this is a kind of a creative elision of the document that fundamentally alters the nature of its meaning. The document actually says the power of sale or any other remedy permitted by applicable law. To give effect to the word other, it has to be some remedy other than the power of sale. So it cannot be the power of sale permitted by applicable law. Well, I don't think that's specific enough to clearly refer to the statutory power of sale.
Can you give me examples of 2 different kinds of powers of sale, like the statutory power of sale versus a power of sale authorized by statute? What would be the difference?
Sure. So the statutory power of sale was enacted in 1912 in an effort to shorten the length of foreclosure, to shorten the length of documents in general. It was an effort to basically avoid carpal tunnel in the recorder's office prior to photocopiers, because you had all of these lengthy documents where lawyers were writing, I hereby assign, grant, set over, sell, convey, and so forth. So acts of 1912 Chapter 5 was passed to say, the word grant shall hereby mean grant, convey, sell, set aside, and have all of this meaning. The word warranty covenant and there's about a paragraph of text that warranty covenants means. Mortgage covenants is differently defined. And there were two other mortgage-related things. One was the statutory condition, which is not in as common use because that didn't make it into the Fannie Mae Freddie Mac model form. And the other is the statutory power of sale, which is certainly more common than not at this point. But the Act is very clear that this isn't a grant of a new power, but that this is a definition that can be incorporated by reference. So there were power of sales for over 100 years before the enactment of the statutory power of sale. So in 1912, every power of sale mortgage had some specifically defined power that was written out at length in the mortgage. And the 1912 Act said that other forms may continue to be used, that the statutory definitions may be modified as circumstances permit. So I would consider the model Fannie Mae form that has may invoke the statutory power of sale, but also you have to send this notice that has the following 6 things to be not purely the statutory power of sale, but the statutory power of sale plus some other provisions. Other mortgages, and they are less common, write out a specific manner in which the sale should occur. There are a number of cases that set out powers of sale in length that I cited in the brief, but admittedly, the statutory power of sale is more common at this point. There's nothing wrong with the statutory power of sale. It's just that it's not in this particular mortgage.
And are there mortgages that say, and the power of sale, but leave off as permitted by statute?
So this is the power of sale or any other remedy permitted by applicable law. So there are mortgages that say may invoke the statutory power of sale. There are mortgages that define a separate power of sale. And there are mortgages that sort of say the statutory power of sale and then place other conditions on it. This one, and there's about 70 or so others that use this particular form, is a little different in that it doesn't specifically invoke the statutory power of sale. It references remedies that are inconsistent with the non-judicial statutory power of sale. And as the land court found, it doesn't seem to have a lot of definition as to what the terms of this sale should be. So one possible reading that brings harmony to the whole mortgage is that a court may order a sale and impose whatever conditions the court feels is appropriate, but the important piece is that these borrowers on reverse mortgages who are all going to be elders of modest to moderate financial means or the grieving estates who've recently lost a family member will have an option to show up in court to...
Yeah, can I hit you on that point a little bit? Because the judge, I'm reading from page 22 of the transcript, says, so it seems to me it's potentially more protective of the consumer to make mortgages conform to the statutory power of sale than leave them wide open with some odd power of sale that is what basically this other thing you're talking about. So he seems to think that his interpretation of that provision is more protective of the borrower than what you're proposing. What's your response to that?
I think there are 2 instances where the judicial versus non-judicial process is likely to reach a different result. These are reverse mortgages, which means foreclosure is likely to be either following death or following, the other common one is a lapse in taxes. So you could have an elder who falls behind on property taxes, who admittedly fell behind on taxes and is trying to get caught back up, but now is working with the city to figure out what the correct number is and get into a repayment plan. And also working with the lender, and if there's a judicial process that permits the flexibility and oversight that makes sure that there's no forfeiture of the property over a small amount as opposed to the frequently mechanical processes that may happen when there's not a judge involved. Similarly, in the case of a borrower's estate, there's a right in the mortgage for the borrowers to repurchase, or the heirs to repurchase for 95% of the fair market value or the amount outstanding, whichever is less.
You're focusing on a different point than the judge, right? It seems like that point is uncontested at the proceeding. You're not, Mr. Murphy goes, I'm not sure that we're talking about different points of view. I take it on that. So I'm just trying to, are you pushing for something that's going to be less favorable to the borrower?
I don't believe so. I believe it is going to be more favorable to the borrower to have a judicial oversight in this process. And if the judge says there's a clear default, foreclosure is the appropriate remedy, foreclose in accordance with the language set out in 183 Section 21, it would certainly be permissible for the judge to say that following a judgment that there had been a default, and after the parties had been available to show up, get into court relatively early on, rather than contesting the same issue possibly a year later in a summary process suit when a small problem has become an enormous problem. But the mechanical protections in 183 Section 21 are adequate for the process of the auction itself.
Okay, thank you. Good morning. Is it Ms. Jekus?
Good morning, Your Honors. Effie Geekas Trebanian for the plaintiffs' appellees, Federal National Mortgage Association, James B. Nutter and Company. The defendants make the issue that is before the court today seem a lot more complicated than it really should be. As the land court has correctly found, what we have here is the interpretation of the plain language of a contract. And before I go further, I would like to mention that although this court obviously owes no deference to the land court, some weight should be given to the fact that it is the land court that issued this decision, a court that was specifically designed and whose whole purpose is to decide these types of issues. Other judges there have reached the same conclusion as Judge Foster, Judge Grossman, Judge Speicher. So this analysis follows a line of reasoning of the other judges there as well.
So you're agreeing that there is, the statutory power can be incorporated into a mortgage in three ways. One is by incorporating the exact language that defines the statutory power of sale of Section 21 into the text of the mortgage. That didn't happen.
Correct.
Secondly, referring to this definition generally by use of the term statutory power of sale. Well, and that's the question. Or three, language in the mortgage defining a power substantially similar to that of the statutory power. That doesn't apply here
And
either.
the land court judge did not agree with that, so it's number 2.
It's referring to this definition generally by use of the term statutory power of sale, but there was no reference to statutory power of sale.
Yes, so the key clause here, obviously in paragraph 20, is the lender may invoke the power of sale and any other remedies permitted by applicable law, and then goes on to talk about a foreclosure sale. So there is no limit.
Excuse me, would that have made sense if, to also have said the lender may invoke the statutory power of sale and any other remedies permitted by applicable law?
I think the word statutory in this case is almost superfluous, because we have here the words power of sale in this mortgage, and we have a statute that specifically deals with the power of sale, 18321.
But I mean, couldn't that also mean if that had said lender may invoke the statutory power of sale and any other remedies permitted by applicable law, that the lender could also invoke the judicial remedy?
And the lender may. I don't think this, when you look at the mortgage, there's no limit to the lender's remedies, and there is nothing in this mortgage that makes it the exclusive remedy that the lender has to foreclose judicially. That is nowhere in this mortgage. So this mortgage is used across the country. Some states are judicial foreclosure states. Maybe they choose to do that there. But in Massachusetts, we can't analyze this issue without putting it in the context of how Massachusetts deals with foreclosure sales. Since the enactment of 18321, Massachusetts has traditionally been a non-judicial state. That's the default. That's what we all expect when it comes to a foreclosure. So that's something that's important to take into consideration. A lot of the case law cited by the defendants is 1800s case law prior to the enactment of 18321. And again, maybe they may choose to take that route, but they don't have to. There is nothing in the mortgage that requires them to do so. In addition, if we look at 244-14, which is the foreclosure statute, there are numerous references in that statute to the power of sale. Power of sale, I think 2 or 3 times. They also omit the word statutory. So the foreclosure statute itself mirrors the language of our mortgage, and at the bottom of that statute, there's talk about 18321. So I think it's a given in the context of Massachusetts that when we see the words power of sale, we are seeing a reference to 18321.
I know this is a matter of contract interpretation, and as you say, we should look at the plain language of the.
Correct.
Aren't we also supposed to construe this against the lender?
If there's ambiguity, but as the land court has found, there is no ambiguity here. The defendants argue in their brief that to include 18321 under the umbrella of applicable law would be, quote, nonsensical. With all due respect to defendants' counsel, that makes no sense. Yes, we're not going to include every random statute of the general laws, but here we have a statute that deals with the power of sale, and the words power of sale are in this mortgage. So I think when you look at it,
So
the two are...
You combine power of sale with other remedy, and you get statutory power of sale. That's your argument?
that 18321 is incorporated under applicable law. If the words applicable law were not in here, maybe there'd be some ambiguity, but they are in
That's what I
here.
was going to ask you. That's, okay.
They are in
Power
here.
of sale mean anything other than statutory power of sale in Massachusetts?
Not currently in the context since it was enacted. With the prior case law before 1912, it would have may have a different meaning, but
Power of sale could have a different meaning,
not since the enactment of the statute, no.
because
I think it's clear what power of sale means when we look at the history of Massachusetts since the statute was enacted. And actually, if you look at the beginning of 18321, it states right in the first paragraph that it may be incorporated in any mortgage by reference. So the legislature, right in the statute itself, contemplates that it can be incorporated. That, unlike defendant's argument, it doesn't have to be spelled out in what is already a very lengthy document. It may be incorporated by reference.
To be made any more lengthy if they just referred to the general law section, wouldn't it? Statutory power of sale
that would be
pursuant to.
ideal. That we wouldn't be here. That would be ideal.
Yeah,
But
if it just said
but it's not
statutory power
necessary.
of sale, if it just said statutory power of sale, that would plainly incorporate it. But this doesn't say that.
So under one of the prongs of Norton, this meets the second criteria. And
Well, you say that, but I mean, are we to ignore the fact that Fannie Mae, which is sort of the norm, you've taken language from Fannie Mae,
includes statutory, the word statutory.
and
yes.
you've omitted the word statutory.
Now, there is a comparison. Defendants in their brief compare the Fannie Mae mortgage to these mortgages, but we have to keep in mind that that is a conventional mortgage. This mortgage is a little different. This is a non-recourse loan. They're reverse mortgages. So it's not going to be identical with the Fannie Mae conventional mortgage.
But it's not different for this, for foreclosure, is it?
No, but they're not identical contracts.
Yeah, I take that, but I mean, the power of the statutory power of sale is a very powerful thing. It means you can basically take someone's property without any judge saying it's okay. And the question, I guess, here is, since this is written by you, and since Fannie Mae uses language which you've chosen to vary from, isn't it essentially on you that you have failed to make it as clear as it should be for a borrower?
That may be so if there were ambiguity, but the land court correctly found that there is no ambiguity with the language here. In addition, in a non-recourse loan, the lender's remedy really is to take back the property when it goes into default. There are no payments. The lender cannot go after the borrower for a deficiency. There's no personal liability. That's the ultimate remedy, is taking back the house. That's the agreement between the two parties. And Judge Foster also, in the Mata case, points out that in Massachusetts, the preference is for a non-judicial foreclosure.
Well, the preference is when you identify that that is a power which you're reserving in the mortgage. I mean, yes, you have the power to do so. I'm a little bit,
There,
this does appear to be a situation in which you have, frankly, a quite lazy lender and legal counsel, which tries to do one national instrument and ignores the fact that some states are judicial authorization states and some states are not. So, and you basically have written something, as far as I can tell, that is for a state which has judicial authorization, because you refer to in any lawsuit for foreclosure and sale, and there will be no lawsuit for foreclosure and sale if you have the statutory power of sale. So what do we do with that?
well, there's no requirement in the mortgage that there has to be a lawsuit before going to sale. There may be one, but there's no requirement. That is not, nowhere in the mortgage is that made the exclusive remedy of the lender. Nowhere in the mortgage are the lender's remedies limited. That is nowhere found in this contract. And the words applicable law are juxtaposed with the words power of sale. So the common sense conclusion here, which the land court has found, is that 18321 is incorporated by reference in that clause, in this mortgage. And ultimately,
Well, I understand the land court judge to have said it's not incorporated in the words power of sale. It's incorporated only in the
applicable.
words and any other remedies. So it would be permissible, in your view, to say lender may invoke any other remedies permitted by applicable law, period, and that would be sufficient?
the clause lender may invoke the power of sale and any other remedies permitted by applicable law is sufficient. But further, there is talk of a foreclosure sale as well in that same sentence or two below that.
Well, it's called, even in states which have judicial authorization, it's called foreclosure, isn't it?
I'm sorry?
Even in states like New York, which require judicial approval, it's called foreclosure.
But there would have to be something in this mortgage making that the only remedy, stating that the lender can only foreclose via an action. And that's not in here. That's nowhere in this contract.
Can you explain,
No, go ahead.
can you explain your argument that since this is not at the notice stage, strict compliance with
Yes.
Chapter 183,
So-
Section 21 is not required?
The defendants make much of this argument that this issue should be decided along the same line of, cases where there's been found that there has to be strict compliance with the power of sale. But the question before the court is not whether there is strict compliance with the power of sale. The question before the court is whether or not the power of sale is even in there to begin with. So, as drafted, this contract, looking at the plain language of this contract, is the power of sale in there, yes or no? That has nothing to do with whether there's compliance with the power of sale, with the various stages of the foreclosure process. Those are apples and oranges. There's a distinction between strict interpretation of a contract, which we have here, and strict compliance with the power of sale. That's not the issue before the court today. So I think that makes it a little confusing, but there is a real distinction between the two.
So can I ask you a question? I'm sorry, I'm a little slow on the uptake here, but if this document had said, instead of what it does say, which is lender may invoke the power of sale and any other remedies permitted by applicable law, forget the first phrase completely and says lender may invoke any remedies permitted by applicable law, that would be enough to include the statutory power of sale?
That would also not limit the remedies.
That would include,
But the fact that the words power of sale are in there makes it even more clear that there's a reference to
that's
183.
the question. I mean, I don't know that, because it's either that the power of sale refers to the statutory power of sale, and that the other clause means any other remedies permitted by applicable law. Or I could see it more clearly if it just said lender may invoke any remedies permitted by applicable law, and then we would talk about the statutory power of sale as being among them, because it seems to me the judge is saying that it's only by virtue of that language, that latter language, any other remedies permitted by applicable law, that we've got the statutory power of sale.
The applicable law is where we have 18321 incorporated.
Right. That's where it is, not in the first phrase.
Right.
Not in the first phrase that refers to
If
the power
applicable law
of-
was not in there, that would be a much, I think,
No,
bigger issue.
well,
Doesn't the power, if you remove the words power of sale, I mean, the inclusion of the words power of sale makes this sentence crazy in terms of a judicial process, doesn't it? It's got to be referring to the power of sale to make any sense, doesn't it?
It seems to be a given that when power of sale and applicable law are put together like this,
Right.
they're not found in different parts of the contract. They're together. They're juxtaposed.
Then can I get back to the Chief Justice's question, which is, I mean, I don't know if this is a lazy lender, but it's a lender writing to a national audience. Is the lender writing to a national audience on power of sale in this sentence? I'm just trying to understand, it's not directed at Massachusetts, right? It's a nationwide provision. But when we read this, is it a nationwide provision dealing with states that have power of sale? Is that?
There may be other states that are judicial foreclosure states.
No, but what I'm saying is, when they reference power of sale in that sentence, are they only talking about states that have powers of sale and not do this through a judicial process? I'm just not sure what.
I'm not familiar with all the other states, but I know that when this is taken in the context of Massachusetts law and tradition, it's incorporated.
But that seems silly, because we know it's not, right? We know it's written for a national
Yes.
lending
Yes.
process. So tell us what it means in that context, because because that's how it was written. It wasn't written for Massachusetts. We're trying to jam it into a Massachusetts law.
And that's why applicable law is even more important here.
Well, but does that mean it's directed at states with power of sale processes as opposed to judicial processes?
It gives the lender the option. It doesn't limit the lender's remedies, no matter which state you look at it from.
I understand that point, but I'm trying to understand is, when this was written by the national bank, the bank for the national audience, was it only dealing with power of sale in that first sentence?
I'm sorry, if it was,
It wasn't dealing with states that had an exclusive judicial process for this.
I'm not sure. I mean, I don't know how that was geared towards other states. But ultimately, I think the land court has reached really a common sense conclusion, and we have to remember that the law is not intended to throw common sense out the window.
I should know the answer to this, but I don't. If I go to New York law or other states which have a judicial requirement of judicial authorization for foreclosure, will I find a statutory power of sale?
I'm not sure about other states. I can't speak to that. I can only speak to Massachusetts. We have the statute, we have a statutory power of sale. This is
Right. I'm
included in
just
applicable
trying to get a
law.
sense of whether statutory power of sale is exclusive to those states which do not require judicial approval, or whether it's there in all states regardless of whether the court must approve or not.
I can't speak as to the other states, but the language here doesn't put that limit on the lender.
And counsel, in the statute in Massachusetts, when it refers, does it limit powers of sale to only those that are statutory powers of sale?
I'm sorry?
Does this general law limit powers of sale to only the kind that are called statutory powers of sale? Is this limiting in some way on other kinds of powers of sale?
This language here, just looking at the plain language, does not create a limit. So it's the lender's option, but they're not required to go through a judicial foreclosure process. I mean, they might choose to do so, I don't know why, but they're not required to. There's nothing in this mortgage that makes that requirement.
Well, I'm talking about the general law, the statute itself that refers to, you can incorporate the statutory power of sale.
Yes.
Are there any other powers of sale other than the statutory power of sale referenced in that general law? Or is it limited by
My
this
understanding is
general
it's the statutory power of sale
That's it? There's no other
That's my
kind of
understanding.
power of sale?
But there might have been before the statute was enacted, but not now.
not since
Have we ever
1912.
have we ever abrogated the other the other forms of the power of sale?
I'm not sure, but
So it's just sort of a matter of practice, maybe, but not a matter of law, that there are no other kinds of powers of sale.
the statute is pretty clear. And again, the case law cited by the defendants, which goes into this point, is all prior 1912.
A question about reverse mortgages, because I mute it when the advertisement comes on for reverse mortgages, but is there anything about reverse mortgages where the borrower, or now the borrower's family, would be able to go into court and defend against some sort of a foreclosure.
I mean, those lawsuits, they don't occur frequently, but they do occur.
There's some actual grounds that would be a colorable ground.
Not as, it's much more limiting than a conventional mortgage. There are claims that are made, you know, by an heir stating maybe that they weren't given a chance to buy the property after the death, but those are rare. They can certainly bring those prior to a foreclosure sale if they choose to.
So
But
they'd have to
again-
go in and, if it were a statutory power of sale, they'd have to come in Superior Court, for instance,
Right.
and seek a temporary restraining order.
Just like any other mortgage. And those aren't common, but of course we do see them. They can certainly file a lawsuit like that if they choose.
Okay, thank you. And
Thank
we'll
you.
We'll take our morning break.